Welcome to the Master Builders Victoria Building Master Builders podcast. I'm your host, Sam Smith. Master Builders Victoria was established in 1875 by a group of distinguished builders intent on raising standards within the industry. Since that time, the organisation has grown to become a preeminent industry voice with members universally renowned for their reliability, skill and professionalism. Today, Master Builders Victoria leads a future-ready industry that builds a better world. During this podcast series, we bring industry experts directly to you to discuss trends and challenges within our industry to empower people to build a better future. The Master Builders Victoria Employment and Industrial Relations team helps members understand their workplace requirements by providing tailored and industry-specific advice, services and resources. From assisting with everyday employment issues to guiding through complex Fair Work Commission matters, they work with members in the prevention, management or resolution of complex challenges unique to our industry. Today we are joined by Adrian Ziccone, Employment and Industrial Relations Manager at Master Builders. We'll be discussing enterprise agreements, their place in the construction industry, and debunk some common misconceptions about them. Welcome to the podcast, Adrian.
Thanks, Sam. Good to be here.
Now, firstly, we're going to talk about enterprise agreements, but what is an enterprise agreement?
That's an excellent first question, Sam. So an enterprise agreement is a statutory collective agreement made between a business and its employees that sets minimum terms and conditions of employment. Enterprise agreements are governed by a framework set in the Fair Work Act, and as part of this framework, the Fair Work Commission must assess and approve an enterprise agreement for it to become legally enforceable. Once approved, enterprise agreements can run for a nominal period of up to 4 years.
Now, who needs an enterprise agreement? Is it for every business?
No, and you don't need to have an enterprise agreement. There's no legal requirement to have one. While it's not a legal requirement to have one, we know some businesses within our industry face industrial pressure to make one. There are lawful avenues that workers and unions as their representatives can take to apply industrial pressure for businesses to bargain and implement an enterprise agreement. There are also unlawful ways for this pressure to be applied, which I'm sure we'll probably circle back to later in this podcast.
So why might a business want to have an enterprise agreement in place?
So there's probably a few different reasons why a business may want to have an enterprise agreement. So for example, they can provide businesses with certainty. So enterprise agreements can set out terms and conditions of employment for 4 years from the date of approval.
So it helps with forecasting then for labour costs?
That's right. And that's really important for our industry just because projects are sort of time-based and sort of, they might run for a year or two and sort of they'll gear up and then sort of gear down. The other reason that I think people might want to look at making an enterprise agreement is that they allow you to better tailor terms and conditions of employment to your business. So they can help you clarify when certain entitlements apply. So it can bring sort of certainty in that respect.
Certainty both for you as a business and for your employees too?
Yeah, it can help avoid sort of ambiguity. Now, the other reason why we see businesses may want to look at making an enterprise agreement for our industry is to help avoid industrial pressure. If they've got an enterprise agreement in place, then generally they will be locked in for that nominal term, and then they won't have questions raised on site whether they've got an industrial instrument because they'll have one, and that sort of can give them a bit of peace of mind and act as a bit of a shield.
So you've talked some positive reasons why you might have one. Why are there reasons why a business might not want to have an enterprise agreement?
Yeah, there's probably a few reasons why you might not want to have one. So doing an enterprise agreement is a bit of a sort of a technical and involved process, and it takes a bit of time, and that can be challenging for businesses to go through. They also may result in sort of additional costs and complexities, especially if they don't meet your business's needs, or if you don't fully understand the terms of a template agreement that you might be signing up to. And the other reason I think people might not want to do an agreement is that they need to be renegotiated every couple of years. So once you've got an agreement, generally you're then locked into a cycle of future agreements just because your agreement will expire and then you'll have to look at making a new one after the nominal term.
So an employer goes through this process. Who's going to be covered by that enterprise agreement?
An enterprise agreement will normally have like a coverage term within it. So the coverage term is generally sort of at the start of the agreement, one of the first few clauses within it, and it will state that it applies to an employer, generally a specific cohort of employees of that employer. So for the construction industry, we find that most enterprise agreements will cover on-site workers. So these include people like tradespeople, labourers, plant operators, apprentices. We generally don't see professional and senior employees covered by an enterprise agreement in our industry. For example, most enterprise agreements don't cover site supervisors or project managers or construction managers and other professional support staff. While I suppose these people could be covered by an enterprise agreement, we generally find that these positions are salaried and those workers have individual employment contracts rather than having a collective agreement apply.
Right. What's the union's role when it comes to enterprise agreements?
They have a representative role for their members.
And are they part of the conversation when you're forming the terms of the agreement as well?
Yes. Generally speaking, they will have been part of the process to negotiate the agreement. So they will have been involved in discussing the terms and setting them and sort of part of the bargaining. So you will probably have been dealing with them quite substantially.
What kind of terms can you include in an enterprise agreement?
There's lots of different terms that you can include in an enterprise agreement. So the Fair Work Act sets out what are permitted to be included in an enterprise agreement. So, broadly, these are terms that apply or concern the employer-employee relationship. So, terms like wages, allowances, hours of work, shift work terms, leave entitlements. They're the sorts of things that you can include in an enterprise agreement. Other permitted matters for enterprise agreements may concern sort of the employer-union relationship. So, terms around participation in union meetings, conditions for training, union involvement in dispute resolution, and so on and so forth. So an enterprise agreement can't just cover anything. So if an enterprise agreement doesn't have a permitted matter, that permitted matter has no effect. So, if it was something around a third party, for example, that didn't concern the employer, the employees, or the union, and revolved around a third party, it probably wouldn't be a permitted matter. And to the extent that there are non-permitted matters in an enterprise agreement, they don't have any effect. So while they might be in an agreement, then they are sort of unenforceable.
Okay. Say an employer does not have an enterprise agreement, what governs those employment conditions?
So where an enterprise agreement isn't in place for a business, and there's lots of businesses out in industry that don't have an enterprise agreement, what will apply as a default is the National Employment Standards, or the NES. And the NES are a set of minimum entitlements contained within the Fair Work Act. They're legislated minimum entitlements and they always apply to employees. So even if you have an enterprise agreement, the NES will apply in the background. You can't undermine or undercut the NES. So the NES contains conditions such as maximum weekly hours, annual leave, personal leave, notice of termination provisions and redundancy pay. So they effectively provide the basis for sort of employment framework in Australia. In addition to that, there's instruments called awards, and they're also sort of known as modern awards, and they may bolster sort of the NES framework to provide additional minimum entitlements and conditions for a particular occupation or an industry. Not all employees will be covered by an award, but a significant number are. So in our industry, the most commonly applicable award is the Building Construction General On-Site Award. Very broadly, this award applies to tradespeople, labourers, operators and apprentices, so largely on-site based work. And another award we find that applies is the Joiner and Building Trades Award, which can apply to tradespeople as well, but it's really focused on off-site work. So joinery work and prefabrication work performed in a factory or a warehouse off-site.
So there's some awards. Employers might have enterprise agreements. Do you ever find that they are in conflict or contradict each other? What happens in that case?
Okay, so if an award contradicts a term in an enterprise agreement, if an enterprise agreement's been approved, it is higher than an award, and it will apply in place of that award unless there's a term that says that through the enterprise agreement, the award continues to apply in the background. So an award can be incorporated into an enterprise agreement and sort of fill the gaps if we look at it that way.
So that might be if the enterprise agreement is silent on some
That's right.
terms, it refers to the default award or
That's right.
professional employment standards.
Where that's the case, enterprise agreements will generally specify that a term in the enterprise agreements takes precedence over a term in the award. So if there's an express subject matter within the agreement, that is what applies instead of the award. Now, sometimes that will provide, and often that will provide a more beneficial entitlement to the worker. For example, it might provide a greater daily travel allowance.
Yep.
But that doesn't necessarily mean that in all instances the employee needs to be left better off. There could be a negotiation, and certain entitlements could then be rolled up or they could be reduced into higher hourly wages, for example. Provided that employees are left better off overall, that agreement could still then be approved.
So the balance of all the terms and conditions, the employee needs to be better off overall.
That's right. So to be approved, each employee will need to be left better off overall. So while the employee could go backwards on some things which then conflict with what the modern awards say, if they're left better off, that still leaves the agreement capable of approval, and that's what will apply. So you look at an agreement, if there is an express term within it that applies, for example, a daily travel allowance, you will go with what the agreement says rather than what the award says on that point.
Are there any clauses that can't be included in an enterprise agreement?
So the Act itself, so the Fair Work Act specifies where clauses can't be included. So the Act says that certain clauses can't be included in agreements where they are discriminatory, for example, or they prevent access to things like unfair dismissal laws. They prevent access to right of entry laws. So there's a list of things in the Act that say that you can't include certain terms in an enterprise agreement. Those things can't be included. So that's just those three items there are a list, but there's a greater subset.
Sounds like they're things that prevent access to an existing legal function.
Exactly. Like,
kind of like you can't undermine an award or the NES either.
You could potentially undermine an award, but you can't undermine the NES. And likewise with the NES, which is in the Act, the Fair Work Act, you can't undermine clauses of the Fair Work Act in terms of what clauses can't be in an enterprise agreement. So, look, a lot of them I think are pretty common sense related things and straightforward, but I suppose, you need to be conscious of making sure that we don't undermine those things, or we don't have clauses that are non-permitted matters effectively.
Right. So say we've got some employers or employees or both listening to this. How do they go about making an enterprise agreement?
Oh, this is a simple one, Sam. Come through Master Builders Victoria. The Employment Industrial Relations team do this as sort of their bread and butter work. We do a lot of enterprise agreements for our members. So whether that is doing an enterprise agreement that's sort of bespoke and tailored for your business, or one that's based on an industry template that sort of has the CFMU as a party to that, we're able to assist members. But look, putting aside that shameless plug, there's quite a structured and technical process to make an enterprise agreement as set through the Fair Work Act. And look, a failure to follow that process may mean that the Fair Work Commission doesn't approve it. So
what happens if they don't approve it?
You go back to the drawing board.
Back to the start?
Back to the start, that's right.
We don't want that.
No. And I suppose, look, circling back, it's a rather technical and complicated process, and I don't know if I'm going to do full justice to it through the podcast, but maybe to give it some flavour. So just broadly, the process will involve bargaining with employees and any employee representatives about the terms of the proposed agreement. That employee representatives could include discussing with the union. It involves drafting up the terms of that agreement. Again, that could be done in consultation with the union, but it doesn't have to. Providing employees with access to the proposed agreement and then taking steps to help them understand it. Conducting a vote for that agreement. And then if their vote's successful, then lodging it with the Fair Work Commission for them to assess and hopefully approve it. For people that come through MBV, we'll guide you step by step through that process. We'll make sure that you've done everything according to the framework set in the Act, and that will give the agreement the best chance of being approved by the Commission.
Now, there's a few different steps in that process that you've just given a very high
level
bit of detail about. How long does that process take, broadly speaking?
Look, we generally find the process takes at least a minimum period of 3 months.
It's a long time for discussions.
It can appear like a long time, but there's lots of things that need to happen in that time, and that's why it kind of pushes out to that sort of minimum period. So given we've got different stages in terms of drafting up the terms of the agreement, negotiating, and then the approval process, inevitably it does turn into sort of that 3-month period that we find as a minimum. It can actually go longer. It could actually take 6 months, 9 months, the whole year, or even more than that. But that's sort of the minimum process, that time that we find. In that, there are some things within the business's control, and there's things that aren't. So, for example, once you lodge the agreement, it needs to get assessed by the Fair Work Commission. That process of assessing and deciding whether to approve the agreement, we find on average takes around 4 to 6 weeks. It can take longer, it can take shorter periods, but there's probably at least a month there, potentially more, where the Commission will be reviewing the agreement before deciding whether to approve it or not.
And that's out of anyone's control, really, other than the Commissioner.
Exactly. And how busy the particular Commissioner is that needs to assess the agreement. So, look, if an employer was to be super diligent with the process and the bargaining, and it was to run as smoothly as possible.
What's that lower time frame?
The sort of the legislated minimum time frame that an agreement could be bargained for and voted on is 21 clear days. And that's the minimum time frame between issuing notices to commence bargaining, doing the bargaining, taking your steps to explain the agreement, and then conducting the vote. Then there's still paperwork that a business will need to prepare for lodgement. That can take a couple of weeks. But look, as sort of a minimum time frame as set in legislation, it's 21 clear days. But look, in reality, things don't ever run as smoothly. And I don't think we've ever had an agreement that's been smack on 21 clear days and then lodged with the Commission. There are inevitably delays. There's operational issues. Business gets in the way of doing the steps sort of as tightly as possible. So we don't necessarily find we ever get to the shortest time frame possible. And that's why realistically we guide members as to sort of 3 months is probably a realistic sort of expectation of how long the process will take.
Does a union need to be involved in negotiating an enterprise agreement?
No. There's no requirement for a union to be involved in negotiating an enterprise agreement. A business can negotiate directly with its employees and any employee-appointed bargaining representatives. That doesn't necessarily mean a union. It could mean a senior or trusted employee or multiple senior and trusted employees that are appointed by their peers to negotiate with the employer. Though it's probably good to note that, look, if you do have union members, the union will be a default bargaining representative for those members. This means that if you are negotiating directly with employees, the union can become involved in the process and represent the interests of their members, and they've got that default status as set in the Fair Works framework.
What are some common pitfalls that people might make when they're making an enterprise agreement?
The process is quite technical, so there's lots of different ways that business can inadvertently make mistakes and not meet approval requirements.
Such as the 21-day time frame that you're talking about earlier.
That's it. We normally see that issues arising around the time frame, that the time frames haven't been met. or the business has missed out on some crucial action steps. Maybe that is, notifying of the vote and providing adequate notice, or it could be that they haven't taken steps to explain the terms of the agreement. And that means that they might need to go back and redo those steps. But if they then sort of do go on to lodge, it could be raised by the Commission, and then it might be an obstacle for approval.
So once a business has lodged their enterprise agreement with the Commission, say the Commission identifies some issues with it, what happens next?
It ultimately depends on the type of issue being raised. If the matter is relatively minor or technical in nature, the Commission may exercise discretion to still approve the agreement. And where this happens, generally what they'll do is they'll note on the decision to approve the agreement that if the concern is related to the terms of the agreement, the Commission may allow the business to provide a written undertaking. An undertaking provides an opportunity to alter or amend the agreement to resolve the issues. So where undertakings are given, they can't result in any financial detriment to employees or result in a substantial change to the agreement.
How quickly from the Fair Work Commission approving an enterprise agreement does it come into effect?
That's a great question.
Is it immediate?
No, it's not immediate. An agreement will come into effect 7 days after approval. So businesses will have an opportunity to make amendments. They might need to do payroll adjustments or system adjustments. Given that an agreement takes 7 days to become operative, that's when sort of those things will need to take place. So not immediate, and you've got a bit of time to sort of adjust anything you need to after agreement's been approved.
Where would I find an enterprise agreement that has been approved?
They're publicly available.
All of them?
They're on the Fair Work Commission's website. You can jump onto the agreements page and do a search. So if you were looking for your own agreement, or if you're looking for someone else's agreement within the construction industry or even other industries, you'd be able to search it on the Fair Works Commission website.
When you say they may have multiple agreements, so can a worker be subject to multiple enterprise agreements?
No, a worker cannot be subject to multiple agreements at one time.
So the multiple agreements might be for different cohorts of employees within that employer?
Yes, that's right. So you might have an agreement that applies to on-site work, for example. You might have an agreement that applies to off-site work, and you might have two separate cohorts that do on-site and off-site work. So a company or a business could have multiple agreements, but they can't cover the same cohort of workers.
Once an agreement is approved, is it set in stone? Can you make any changes to it?
It's pretty hard to make changes once an agreement is approved. That doesn't mean it's impossible, though. So in most cases, if a business seeks to change an agreement, it will need to be done through what's called a variation. And a variation is quite an involved process, just like making an agreement, and it will require several steps to be followed. And part of that is providing employees with information about what the variation is, and also conducting a vote with employees about the variation. So like you need to vote up an agreement with employees, you also need to vote up a variation. So it can be quite difficult. Once, if there is sort of a successful vote for a variation, there needs to be lodged with the Fair Work Commission, who then sort of assesses it and then decides whether or not to approve the variation.
So it's better to get it right to begin with.
Absolutely. It's better to get it right to begin with because it can be quite difficult to change.
Now, what does a business do if they want to terminate an enterprise agreement?
It is possible to terminate an agreement, but again, it's quite challenging. There's two main pathways to terminate. The first one is that an enterprise agreement can be terminated by agreement between a business and employees. So a company would need to, or a business would need to go through a process, and employees would need to vote for the termination of the agreement. Then it would need to then be lodged again with the Fair Work Commission. If a business does go down that path, then the Commission needs to consider the views of any union that's party to the agreement in deciding whether or not to terminate it. So you could get your employees to agree to the termination, lodge it, and then you may have the union come in and try and veto that. So
if they were a party to the original agreement.
That's right. So that's the first way. The second way is that an agreement can be terminated by application to the Fair Work Commission after it's past its nominal expiry. So if an agreement's run for 4 years, after it's run for that entire 4-year period, you can make an application. So not like a vote, like in the other pathway, you can just do it by application. This application pathway has been significantly tightened in the last few years through a few different legislative amendments. And for the application to be successful, the Commission needs to be satisfied the termination is in the public's interest. It will also need to consider the views of employees and in any union and the effect the termination would likely have on them.
Question for you about nominal expiry and how long an agreement might run for. They generally have a period of time specified. What happens when they reach their end date?
Nothing effectively. They continue to operate just as they did before. So at the end of a nominal period, so say for example, after the end of a 4-year period, if a business went for a 4-year nominal term, the agreement would still continue to operate. It would just be that the business and its employees could then start negotiation for a new agreement.
All right, we might go a bit more rapid fire with the question and answer. So maybe
this is great, Sam. Let's do it.
It's fraught with danger, but perhaps a yes, no, and if there's a couple of
key points
that you need to add, go for it. But we get there's a lot of perhaps misconceptions about enterprise agreements that businesses may not fully get right. So I'll throw a couple at you, and perhaps you can clarify whether it's true or not.
Let's do it.
You must have an enterprise agreement to work in the construction industry.
No, you don't have to have an enterprise agreement to work in the construction industry.
All contractors must have a union enterprise agreement to work on a commercial or civil site in Victoria.
No, that's not a requirement either. You don't have to have a union enterprise agreement to work on any project in Victoria.
A CFMEU enterprise agreement only applies to a union site.
No.
What is a union site?
There's no such thing as a union site. It might just be a site where there is union presence. It might, there might be a union delegate on that site, but a union site is a bit of a misnomer.
The union can stop me working if I don't have a CFMEU enterprise agreement.
No, they can't stop you from working. There are potentially a couple of issues in that that could be unlawful. There's no requirement to have a CFMEU agreement to do work.
You can go down to the union's office to sign the enterprise agreement.
We hear this one quite a bit. No, you can't just go down to the union's office to sign the enterprise agreement. There's an entire process set in the Fair Work Act that must be followed to make
going back to that 21-day and more like a 3-month time frame that you were
That's exactly right.
Enterprise agreements cease to operate after nominal expiration.
No, they continue to operate even after their nominal expiry date, and they'll continue to operate up until they're either replaced with a new enterprise agreement or they're terminated, whether by application or through a vote of employees.
The enterprise agreement stops applying if I move the workers into a new affiliated company.
This one here is potentially tricky, but generally speaking, an enterprise agreement will continue to apply. So there are some transfer of business and transfer employees and transfer instrument terms within the Fair Work Act. And in many cases, just moving an employee from one business to another doesn't mean that an enterprise agreement stops applying to them.
Finally, the enterprise agreement applies to all people working on the site.
No, it will apply to the people covered by, or the workers covered by the enterprise agreement. So they will be those nominated in the coverage term as to who it covers. We generally find in our industry there are multiple subcontractors that work on site. An enterprise agreement will apply to the employer and its employees. It doesn't apply to all the other subcontractors that may come onto the site.
Just to expand on that unlawful bit, what are some unlawful practices in relation to enterprise agreements?
Unlawful practices could be things that are prevented in the Fair Work Act. So, for example, a person, which could include a union official or a union delegate, can't discriminate against an employer because that employer has or doesn't have an enterprise agreement with its employees. For example, it would likely be unlawful if a union delegate on a project prevented a subcontractor from commencing work on site because they didn't have a union enterprise agreement.
All right, now there's a lot of information that we've covered today. If there's someone out there that's thinking about starting the enterprise agreement journey, what's their take-home message for them?
Get in contact with Master Builders Victoria's Employment Industrial Relations team. We do this on a day-to-day basis. We're always assisting members in making enterprise agreements. We understand all the requirements, the pitfalls, and we'll hold your hand in making the enterprise agreement. Also, we'll be able to provide some guidance as to options and sort of the benefits of those options and potential detractors from those options. Look, an enterprise agreement isn't always suitable for every single business. It's not a requirement to have one, but we'll be able to guide you as to your circumstances as to whether you might want to consider making an enterprise agreement or not. We'll give you that tailored advice, and then we help you through the entire process, help you with the drafting, help you with potentially negotiating with employee representatives, help you with the lodgement, and hopefully through to get an agreement approved.
Or perhaps if an agreement isn't the right outcome, understanding then the national employment standards and any applicable awards.
That's right. So if enterprise agreements aren't suitable for your business, we'll help you understand your requirements, whether that is via the NES or an applicable award. We'll make sure that you're understanding and help you comply with your obligations.
So how do they get in contact with you?
Give us a call on our main line, which is 9411 4555, or email us at eir@mbav.com.au.
Thanks so much for your time, Adrian.
Thanks, Sam. Good being with you.
This podcast was recorded on Wurundjeri land. MBV pays respect to elders past, present and emerging.
The information contained within this podcast is general in nature. It is not intended to substitute professional advice and should not be relied upon as such. We encourage members to seek personalised advice where appropriate.